Welcome to day 2 of the conference Unclos at 40, an assessment, brought to you by the NUS Center for International Law. I am Pia Benosa from the Ocean Law and Policy team of CIL, and together with my colleague Dr. Tara Davenport, we will be walking you through today's sessions on the place of Unclos among other legal regimes, Unclos in the face of contemporary challenges and developments, Unclos within the region, and finally, a stock-taking of the last 40 years of the convention and prospects for its future. I am pleased to formally open panel 4 of the conference on Unclos and other regimes, harmony or fragmentation. It is my honor to introduce the moderator of this panel, Professor Ronan Long of the World Maritime University in Malmö, Sweden, and director of the WMU Sasakawa Global Ocean Institute. He is joining us from Sweden, where it is currently 3 a.m. Prof, good morning, and the floor is yours.
Good morning, and thank you so much for that very gracious introduction. Your Excellency, distinguished judges, ladies and gentlemen, good morning to everybody attending the conference in person in Singapore, as well as to the global audience across the world who are joining remotely. It is indeed a great privilege and honor to join from the WMU Sasakawa Global Ocean Institute in Sweden. I wish I was with so many friends and colleagues in beautiful Singapore this morning. First and foremost, I wish to congratulate Ambassador Tommy Coe, who has made such a lasting impression on the world stage through his leadership and support for the international rule of law and the ideals of the Charter of the United Nations. Among his many illustrious achievements, we owe him a great debt of gratitude for steering the Third Law of the Sea Conference to a safe harbour. Indeed, his great friend, the late Ambassador Elliot Richardson, once famously described the Third Law of the Sea Conference as the hardest thing that he had ever done, and compared the negotiations to a combination of no limits poker and three-dimensional chess. Ambassador Mahon Hayes, head of the Irish delegation, a leader of the Margineers at the conference, told me the conference was a great success in part because of the strong conference leaders, such as Ambassador Coe, and that they all had become great friends by the end of the process. This is very similar to what we heard yesterday from Ambassador Rina Lee in relation to the BBNJ negotiations. We wish her every success. This morning, I would also like to say a very special thank you to my long-standing and dear friend, Professor Nilofer Oral, as well as my many colleagues at the Center of International Law. In particular, I wish to extend a very warm greetings to Emeritus Professor Bob Beckman and Dr. Tara Davenport, both of whom have helped us deliver our mission here at the World Maritime University. Ladies and gentlemen, the subject matter of this vital conference, Unclos at 40, an assessment, could not be more timely or indeed germane to our world today. Moreover, we live in auspicious times. This past 2 years has brought its own challenges for everybody in the maritime and ocean communities. Here at the Sasakawa Global Ocean Institute, it is incumbent on us to pay special tribute to the vital work of the maritime communities across the world in keeping the international trading system functioning throughout the pandemic. We would also like to echo the words of Ambassador Coe yesterday. The maintenance of international peace and security in relation to the ocean is probably the greatest achievement of Unclos over the past 4 decades. Everyone in this audience knows that Article 301 of the Convention is very clear in that it prohibits any threat or use of force in the attainment of the objectives of the Convention. As highlighted by many of the speakers yesterday, we should not forget that one of the great strengths of the Convention is that it provides a sophisticated framework for the peaceful settlement of disputes under Part 15. It maintains a very fine balance between voluntary and compulsory procedures. As highlighted yesterday by Judges Hoffman, Judge Jesus, and Judge Hyder, amongst others, The contentious and advisory jurisprudence of Unclos has added greatly to maintaining a stable and peaceful public order in relation to the ocean. Ladies and gentlemen, we have an extraordinary erudite panel of contributors that can share valuable insights with us this morning on how to build a very stable and peaceful future for humankind in relation to the ocean. The panel will address Unclos and other regimes, harmony or fragmentation, perhaps a very provocative title. Our first speaker is Professor Chi Kojima from Chuo University in Tokyo. She completed her JSD at Yale University. I'm very happy to say she previously worked as an assistant professor of maritime law and policy at the World Maritime University in Malmo, and as a senior researcher at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, the home of my dear friend, Judge Rudiger Wolfram, for much of his career. Professor Kojima will speak on the topic Unclos and International Environmental Law. We are very happy to see you remotely this morning from Tokyo, and we're very happy that you can deliver your paper. Professor Kojima, you have the floor.
Good morning. Do you hear me? Yes?
Yes.
Okay, thank you. Good morning, Excellencies, colleagues, ladies and gentlemen. Thank you, Professor Long, for your kind introduction. I'm Chie Kojima, Professor of International Law at Chuo University in Japan. First of all, I would like to thank Ambassador Tomiko and the Director of CIL, Dr. Nilüfer Oral, for kindly inviting me to this very interesting conference. It is a great honor for me to join this panel with the other distinguished speakers. Also, I feel pity that I couldn't join you today, but it's a beautiful day with full of cherry blossoms here in Tokyo, and I can share the picture at the end of my presentation. Today, I'm given the daunting task of addressing harmony and fragmentation between Unclos and international environmental law within 15 minutes. The other speakers on this panel will also touch upon environmental issues. So I have chosen to shed light on the integration of general principles of international environmental law in the Unclos regime. As a preliminary matter, I would like to question the scope and nature of international environmental law and the law of the sea. The preamble of Unclos indicates that one of the objects and purposes of Unclos is to establish a legal order for the seas and the oceans, which will promote the conservation of their living resources and the study, protection, and preservation of the marine environment. This clearly indicates that Unclos and international environmental law share the same goals. When we talk about fragmentation, however, international environmental law cannot be an equivalent partner or counterpart of the law of the sea. International environmental law has not been systematically codified into a single treaty or group of treaties like the Unclos regime. International environmental law is a mixture of various binding and non-binding instruments from which several general principles of law have achieved the status of customary international law. The Unclos regime, on the other hand, is relatively systematic and coherent in nature. Having said that, its content has been challenged by new situations, and the scope of the regime is getting blurry due to the increasing interaction with other branches of international law. Perhaps nobody disagrees that an Unclos regime in a narrow sense includes the convention itself and the two implementation agreements, or potentially 3 if the BBNJ agreement succeeds. However, I would like to point out that an Unclos regime could also include various binding agreements that have been created to implement the objects and purposes of Unclos at the universal, regional, and bilateral levels. As rightly pointed out by Dr. Ridings and Professor Mossop yesterday, the unique practice of the UN's fish stock agreements implemented by RFMOs is a good example of this. Furthermore, international rules and standards in the forms of guidelines, code of conduct, or even goals adapted through the competent international organizations could also form a part of the Unclos regime in a broad sense. I believe the recently published book by Professor Natalie Klein entitled Unconventional Lawmaking in the Law of the Sea beautifully collects such examples, and we should all read that book. And lastly, and certainly, rules of customary international law are also a part of Unclos regime as its preamble stipulates. Having all these in mind in my presentation, I will only focus on the parts which are clear that are recognized general principles of international environmental law and the Unclos regime in the narrow sense. Now, I will briefly highlight the interaction of Unclos and international environmental law through the lawmaking processes. As we all know, the development of international agreements related to the prevention, mitigation, and control of marine pollution predates the adoption of Unclos. However, environmental issues had not been a major focus at the first and second conferences of the Law of the Sea. The Geneva Conventions concluded in 1958 included only a few provisions related to marine pollution. In 1972, the Stockholm Declaration provided in Principle 7 that states should take all possible steps to prevent pollution from the seas by substances that are liable to create hazards to human health, to harm living resources and marine life, to damage amenities, or to interfere with other legitimate uses of the sea. By the way, I believe this principle remains applicable to all the contemporary challenges that we face today, including climate change. The Stockholm Declaration and the adoption of several international conventions addressing the prevention of marine pollution, including the London Convention and MAPO, promoted the adoption of a comprehensive set of rules under Part 12 of Unclos. Against this background, the main focus of Part 12 of Unclos was centered around the obligation of states to prevent, mitigate, and control all sources of marine pollution, and to allocate legislative and enforcement jurisdictions of flag, coastal, and port states. Negotiators are aware of the fragmentation issues, and therefore Article 237 was inserted in the convention, which provides that special conventions related to the protection and preservation of the marine environment should be carried out in a manner consistent with the general principles and objectives of the convention. The evolution of Part 12 is remarkable after the 1990s. The adoption of precautionary principle in the Rio Declaration, as well as a series of international instruments on the conservation of marine living resources, have influenced the continuing development of the Unclos regime after its adoption. The 1995 UN Fish Stocks Agreement is a major achievement in this regard, and the agreement became instrumental in bringing in general principles of international environmental law, such as the precautionary approach and the sustainable utilization of fisheries into the Unclos regime. In 1999, Unclos stated in the southern bluefin tuna case that the conservation of the living resources of the sea is an element in the protection and preservation of the marine environment. It was also confirmed in the Chagas case in 2015 that Article 194 is not limited to measures aimed strictly at controlling pollution, but extends to measures focused primarily on conservation and the preservation of ecosystems. The award of the South China Sea arbitration goes into the same direction. So among various means of integration that we discussed yesterday, I would like to highlight that in terms of integration of general principles of international environmental law into Unclos, a means of integration by interpretation using the principle of systematic integration under Vienna Convention on the Law of Treaties, Article 31, paragraph 3c, has played an important role, in addition to the adoption of an implementation agreement. In this regard, it is remarkable that a number of environmental principles have been recognized in the provisional measures and advisory opinions of the international tribunals of the law of the sea. Excuse me. Some principles appear in Unclos, but in a rather limited way. For such instances, interpretation through the tribunal has helped connect the elements in the convention with the principles in international environmental law. Other principles do not appear in Unclos at all, but environmental principles were brought into the Unclos regime by using the adoption of the implementation agreement as a step. And then the interpretation by the tribunal followed to give an integrated understanding of the entire Unclos regime. Now, I would like to highlight a few examples. A famous example is a precautionary principle. Unclos doesn't have an explicit mention of the principle. The notion of precautionary approach itself has been established in international law only after the adoption of Unclos, namely in the Principle 15 of the Rio Declaration. In the southern bluefin tuna cases in 1999, the tribunal expressed its view that the parties should act with prudence and caution to ensure that effective conservation measures are taken to prevent serious harm to the stocks of southern bluefin tuna. In the advisory opinion in 2011, the Deep Seabed Chamber stated the precautionary approach has been incorporated in a growing number of international treaties and other instruments, many of which reflect the formulation of Principle 15 of the Rio Declaration. In the view of the Chamber, this has initiated a trend towards making this approach part of customary international law. There is also no explicit mention of common but differentiated responsibility under Unclos. Similar to the precautionary principle, there was only a slight element in the preamble, which refers to a just and equitable international economic order and the need to consider the special interests and needs of developing states, whether coastal or landlocked. The fish stocks agreement stipulated the obligation of the parties to give full recognition to the special requirements of developing states in relation to conservation and management of straddling fish stocks and highly migratory stocks. Furthermore, the advisory opinion in 2011 reiterated that Principle 15 of Rio Declaration provides that the precautionary approach shall be applied by states according to their capabilities, and that the requirements for complying with the obligation to apply the precautionary approach may be stricter for the developed than for the developing sponsoring states. The ecosystem approach has been introduced by the conferences of the parties to the CBD and by the FAO in the context of fisheries management. Unclos, again, doesn't have any explicit reference to biological diversity. And again, it only contains some elements that are indicated by the term rare or fragile ecosystems, or the phrase, the habitat of depleted, threatened, or endangered species and other forms of marine life under Article 194, paragraph 5. The fish stocks agreement is remarkable in this regard. It stipulated the ecosystem approach under Article 5E as one of the general principles. Also, the ecosystem approach still has some room to develop in the Unclos regime, but it is noteworthy that the award of the South China Sea arbitration relied on the principle of systematic integration and interpreted these terms under Part 12 of Unclos in light of CBD and CITES. Furthermore, the area-based management tools within the areas of national jurisdiction have gained much support under the CBD regime. And I also believe what the future of the ongoing BBNJ negotiations will be the decisive factor for the ecosystem, for the introduction of ecosystem approach into the Unclos regime. Excuse me, one more slide before my conclusion. In a number of cases brought before the Unclos, the duty to cooperate is also recognized as a fundamental principle in the prevention and preservation of the marine environment under Part 12 of the Convention, and also under general international law. And I don't have to repeat that this duty of cooperate has been recognized in a number of international instruments, environmental instruments, including Principle 24 of the Stockholm Declaration and Principle 7 of the Rio Declaration. And also this duty to cooperate appears in international environmental law in the form of procedural obligations, such as duties to notify, consult, and negotiate, which help eliminate and minimize adverse environmental effects. And this is confirmed in a number of ICJ judgments as well. So I would like to conclude my presentation with my observation about the future of Unclos Part 12. There is a consensus that the law of the sea scholars and practitioners consider Unclos as a living instrument today. And in fact, Unclos Part 12 has interacted with general principles of international environmental law that had been evolving by themselves at that time. This already indicates that Unclos Part 12 can serve as a foundation and a link for other specific environmental regimes. With these developments in mind, I would like to point out the following. First, the importance of Article 194, paragraph 5 may increase as marine living resources get scarce and economic activities increase at sea. Second, the notion of the pollution of the marine environment under Article 1, paragraph 1.4 may be broadened to meet the present day challenges. And the examples include climate change, marine plastics, and underwater noise. And fourth, ongoing discussions also suggest that the possibility to use the Unclos dispute settlement mechanisms for international environmental disputes. Maybe later my colleagues might touch upon that issue. And finally, a human rights-based approach to the marine environment, including the rights of future generations, need to be discussed and further considered in meeting the needs and the challenges that we face today. Thank you very much for listening. This is the end of my conclusion. And as I promised, sorry. Sorry, this is the cherry blossoms that are blooming all over in Tokyo today, and I wish you a nice day. Thank you.
Professor Kojima, a really wonderful exhibition in terms of the convergence of environmental principles with the law of the sea convention, and we particularly enjoyed your last slide. Of course, you will give our very happy regards to all of our dear friends and colleagues in the law of the sea community in Japan. I think perhaps your presentation is a great example of the convention as a living instrument, as well as the important role international courts and tribunals play in its implementation. I think you reference very importantly cases 17 and 21, the advisory jurisprudence of the tribunal, as well as the Chagos arbitration and of course the Annex 7 arbitration in relation to the South China Sea, all of which have added to our understanding as to how to apply these principles in the context of the law of the sea. It's very relevant that you highlighted the precautionary principle, or indeed the precautionary approach, which is an issue at debate at the BBNJ negotiations. And I was very happy to see that you cited that its standing as one of an emerging rule of customary international law. Likewise, I think it's very important that you highlighted common but differentiated responsibilities, both in the context of the interpretation of that by the tribunal in cases 17 and again in case 21, as well. Of course, you mentioned the ecosystem-based approach to management of the marine environment, a very contemporary issue in relation to BBNJ negotiations. A fundamental issue which you've highlighted was the duty to cooperate, and I think that permeates all aspects of the convention. Indeed, it was highlighted by many of the contributors yesterday, and I would instance Professor Wolfram in his separate opinion of the Max Planck case, where he described the duty to cooperate as the grund norm, that is to say, the basic norm of the marine environmental protection provisions in the convention. And I think that speaks very well. And I think you've really set the stage for our two contributors this morning in relation to the application and implementation of these principles in other domains, including in relation to international maritime transport, as well as in the context of climate change. Thank you very much. Without further ado, I would ask our panelists to perhaps study some of the questions that are going to be posted in the Q&A function. I would encourage the global audience to post some questions in the chat function. And next, I'd like to turn to our second speaker, who is Dr. Dorita Lost-Seminska. She is Deputy Director and the Head of the Legal Affairs Office at the International Maritime Organization. And of course, here at the World Maritime University, we're a child of the International Maritime Organization. And so it's a particular honor and privilege to introduce Dorota. She has a Master's of Law and a PhD in International Maritime Law from the University of Gdansk in Poland. And she is an alumnus of our sister institution, the IMO International Maritime Law Institute in Malta. I think we can have no better person in the world to speak of on the topic of Unclos and the IMO. Dr. Dorota Las-Seminska, you have the floor.
Thank you very much, Professor Long. Good morning, ladies and gentlemen. It is a great pleasure for me to be here today in person with you. And I particularly would like to thank Professor Tommy Koch and Dr. Nulfar Oral for inviting me here and for giving me this opportunity this morning to talk about Unclos and IMO. I have a very difficult task to capture the 75 years of IMO and 40 years of Unclos in 15 minutes, but I will, of course, do my best. The idea of establishing a global body to regulate shipping became popular after the sinking of Titanic in 1912. The first Safety of Life Convention was adopted in 1914, and then it was taken over by IMO. For the benefit of those who are not familiar with the organization, let me first briefly introduce you to the IMO, what it is and what it does. The IMO is the specialized agency of the United Nations established in 1948 through the adoption of the convention at the Geneva Conference. The headquarters of the organization is in London, United Kingdom, since 1958, which is the time when the convention entered into force. Currently, IMO has 175 member states and 3 associate members and has 5 regional offices. It has also numerous observer delegations, IGOs and NGOs. The secretariat of the organization is quite small. If you consider the global character of the organization, there are 300 staff members working in London facilitating the operation of the organization. And there are 6 official languages of the organization, which made our life quite difficult, especially when we had to move to the remote modalities during the pandemic, and all our meetings had to be interpreted into 6 languages. You can imagine what a headache it caused to us. The organization is the global standard-setting authority for the safety and security of shipping and the prevention of pollution from ships. IMO is a regulatory body with a mission of safe, secure, and efficient shipping on clean oceans. IMO vision for the 6-year period of 2018 to 2023 is to keep the leadership role as the global shipping regulator, taking into account the 2030 Agenda for Sustainable Development. So this is one of the examples already how IMO is aligned with the UN overarching goals and how they are also reflected in the IMO regulatory framework. Over the 65 years of its operation, there were more than 50 treaties and protocols adopted under the auspices of the organization. The IMO regulates all aspects of shipping: safety, prevention of marine pollution from ships, liability and compensation, and other matters. All IMO instruments are interlinked to Unclos. Some of them were developed before Unclos entered into force, some of them were developed after that, and we will be talking about that. And of course, the underlying principle of all our conventions is how to give effect to those conventions, and IMO conventions are only effective when they are then translated, implemented, and give effect in the national legislation. And for this purpose, IMO has a very well-developed technical cooperation program in which we do help member states, in particular developing states, in giving effect to the IMO treaties in the national legislation. Many of IMO treaties and protocols were developed in response to marine casualties. Besides previously mentioned Titanic and the first SOLAS Convention, the most famous example is the Torrey Canyon disaster in 1967, which resulted in huge oil spill causing a catastrophic environmental damage. In the aftermath, the IMO adopted MARPOL, which was already mentioned today, and oil pollution and compensation regime, which is one of the most robust liability and compensation regime in the maritime world. IMO treaties are developed by IMO organs such as the Maritime Safety Committee, Marine Environment Protection Committee, or the Legal Committee. Those committees, those bodies are supported by various very specialized subcommittees, working groups, drafting groups, and the treaty-making process at IMO is very complex, and it is a subject for a separate 2 hours presentation. Unclos was adopted when IMO already existed, and its legal framework concerning the safety of navigation, prevention of marine pollution from ships, or training and certification of seafarers, as well as liability regime, were very well developed. In order to ensure that IMO treaties comply with Unclos and vice versa, that Unclos does not undermine existing legal framework, the IMO Secretariat took very, very active part in the 3rd United Nations Conference on the Law of the Sea. After 1982, consultations continued between IMO and DOALOS, and they continue today as well. Our main objective, the IMO's main objective, was to prevent overlaps and to promote harmony between Unclos and IMO treaties. As mentioned many times yesterday and today, Unclos is acknowledged to be a framework convention. Unclos establishes general principles and rules and refers in particular to the area of safety of navigation and prevention of marine pollution from ships. The overlapping or the conflict between Unclos and IMO regulatory framework was avoided thanks to careful negotiations and inclusion in several IMO treaties of non-prejudice clauses. Examples of such clauses in treaties adopted before 1982 are contained, for example, in MARPOL, STCW, or SAR conventions, which state that nothing in the convention shall prejudice the codification and development of the law of the sea. IMO treaties adopted after 1982 contain concrete references to Unclos. And a good example here is the Ballast Water Management Convention, which in its preamble recalls Article 196 of Unclos and makes specific references to the United Nations Convention on the Law of the Sea. On the other hand, Unclos contains many references to the competent international organization, specifically those provisions of Unclos that provide framework for the safety of navigation and the prevention and control of marine pollution refer to the obligation of states to adopt specific rules and cooperate through a competent international organization. Article 94 of Unclos imposes obligation on states to conform to generally accepted international regulations, procedures, and practices, bearing in mind that treaties such as SOLAS, MARPOL, Civil Liability Convention, SUA, are binding for most of the member states and almost 100% of the world commercial shipping tonnage. They certainly can be considered to be generally accepted international regulations. Since Unclos refers not only to regulations, but also to procedures and practices, it covers not only all treaties adopted under the IMO auspices, but also all codes, recommendations, and guidelines. And believe me, there are thousands of them, covering all aspects of shipping. Many of IMO 175 member states, or almost all of them, are also states parties to Unclos. And those who are not states parties to Unclos consider it as customary international law, and therefore also reflect this in the daily work of the organization. IMO gives effect to many provisions of Unclos. For example, piracy is on the agenda of the Maritime Safety Committee, prevention of marine pollution from ships on the agenda of Marine Environment Protection Committee. Marine casualty investigation is on the agenda of one of the subcommittees and also on the Maritime Safety Committee agenda. The ice-covered areas and regulations contained in the Polar Code are on the agenda of both Maritime Safety Committee and the Marine Environment Protection Committee. This shows how IMO, on a daily basis, in its daily work, reflects principles and provisions of Unclos. IMO regularly cooperates with Unclos parties. IMO provides input to the resolution on oceans and the law of the sea, and also to the report on oceans and the law of the sea. We participate regularly in the meetings of states parties to Unclos as an observer delegation, and we also take an active part in the BBNJ negotiations. IMO also provides input and participates in the informal consultative process on oceans and the law of the sea. All this can be found on both IMO website and the UN website, where all the reports are uploaded, are available, and the contributions by specialized agencies and competent international organizations are available. Two examples of the current interactions between IMO and Unclos, famous negotiations on BBNJ, and Ambassador Rina Lee yesterday gave a very, very good overview of where BBNJ is now and what is the stage of the negotiations. Of course, for IMO and for the IMO regulatory framework, the current work on BBNJ is of an utmost importance. We are especially watching and looking at area-based management tools and how those tools and measures will affect shipping and IMO regulatory framework. Also, in terms of the environmental impact assessment, how this will affect, and if at all it will affect shipping. And of course, also what is important as are cross-cutting issues and what mechanism, what cooperation mechanism will be included in the BBNJ agreement. What is important that is already negotiated and is already decided in terms of BBNJ is that the instrument should be consistent with Unclos, meaning also that there is a room for competent international organizations and that the new agreement will not undermine existing relevant legal instruments and frameworks and relevant global, regional and sectoral bodies, such as IMO. And this is very important for us that here the cooperation and coordination between IMO is the same as with Unclos and states parties to Unclos. And another example of the relevance between Unclos and IMO are the newest developments related to maritime autonomous surface ships. What is going on currently at IMO is that the Maritime Safety Committee and the Legal Committee finalized so-called regulatory scoping exercise, which aim was to analyze IMO treaties from the perspective of how they address, whether they allow or they prevent the operation of MAS. The Legal Committee and the Maritime Safety Committee already concluded this exercise. The Facilitation Committee is going to conclude it this year, and the next step will be to establish a joint working group, IMO, MSC FAL legal working group, to come up with the common definitions and to address common concerns, such as the definition of the crew, of the master, of the seafarer, of the remote operator. And this, of course, is very relevant to Unclos, and as we are aware, and as it was mentioned yesterday, Unclos provides that there has to be a master and a crew on board of ships. So the question is how this will be addressed in the future. I'm almost concluding, and my conclusion is that the IMO is on its path to address mass operations. We report on this to Unclos states parties. We cooperate in these terms with DOALOS. The advantage that IMO has is its treaty-making process and the tacit acceptance procedure, which allows us to amend our treaties as and when required, and whether it will be in a very near future or a little bit later on, I can assure you that MAS, the autonomous vessels, will be addressed within the IMO regulatory framework. The question is then how Unclos, as a living instrument, will address operation of MAS. How we do see IMO and Unclos, certainly as a harmony, not a fragmentation. It is a harmony, it is a very, very well functioning organism, and IMO member states are very well aware of their obligations under Unclos, and also states parties to Unclos are very well aware of the existence of IMO and of our bilateral cooperation. It is a very, very beautiful example of the cooperation between member states and between two huge, very, very important organisms in terms of the global ocean governance and taking care of the future of those of our oceans within the framework of Unclos and the robust IMO legal framework. I will be more than happy to answer any questions that you or the online participants may have. Thank you very much.
Dr. De Rosa, thank you very much. I think especially nice for me to get up at 3 o'clock in the morning to listen to such wonderful presentations. Of course, the IMO treaty regime was incorporated into Unclos by a very clever drafting technique of the rules of reference provisions. And this has enabled an evolutionary approach to treaty interpretation. That is to say, Unclos is read and interpreted in light of other treaty regimes. I think a very good example of that was in the Annex 7 arbitration in relation to the South China Sea, where the arbitral body ruled that a violation of the collision regulations was a violation of Unclos itself. I'm particularly happy that you've highlighted subsequent developments, including the Polar Code, as well as MAS. And of course, this year is the 50th anniversary of the 1972 London Convention, the Dumping Convention. Of course, that preceded the negotiations of Unclos. This year is also the 50th declaration of the Stockholm Declaration of the Human Environment, and the origin of many of the principles and approaches highlighted by Professor Kujimo have their origin in the Stockholm Declaration. I'm also very happy to tell the delegates attending the conference this morning, and indeed the global audience, that here at the Sasakawa Global Ocean Institute, in conjunction with IMO, we will be hosting a conference later this year to mark the 50th anniversary of the London Convention and indeed the Stockholm Declaration. Please post your questions, those participating remotely, in the chat function, and of course, we'll be turning to the audience in due course for the question and answer session. Now, I'd like to turn to our third and final speaker, Professor Timothy Stevens, known to everybody in the Law of the Sea community. He's Professor of International Law at the University of Sydney Law School, where he joins us today. I think it's perhaps in the early afternoon in Sydney. Tim, who is a world-renowned scholar in public international law, law of the sea, international environmental law, and indeed international dispute settlement. Recent co-edited publications include the Research Handbook on Ocean Acidification Law and Policy, as well as co-editing a volume on global environmental change and innovation in international law, which was published by Cambridge University Press in 2018. The title of his paper this morning is Unclos and Climate Change, very topical, one of the big issues for humanity. I think we refer to climate change now as the climate emergency at the World Maritime University. It is of a direct interest to everybody participating in this conference. Professor Stevens, you have the floor.
Well, thank you most kindly, Professor Long, for that introduction, and many thanks also to Ambassador Coe and to Professor Oral for the invitation to speak at this remarkable conference, and good morning, everyone. Well, we know the oceans are changing at a scale and a pace that would have been unimaginable to most negotiators at the Third UN Conference on the Law of the Sea. Unclos 3 took place well before the Intergovernmental Panel on Climate Change was established in 1988, and before the UN Framework Convention on Climate Change, the UNFCCC, was concluded in 1992. The global oceans, the most important component of the climate system, are now in a process of rapid transformation because of human disturbance to the carbon cycle that has released hundreds of gigatons of greenhouse gases into the atmosphere, around 30% of which have been absorbed by the oceans. The IPCC, in its 2019 special report on the oceans and the cryosphere, provided a comprehensive summary of a large volume of science and confirmed a number of troubling ocean indicators, including that the oceans are warming, that their chemical composition is changing as they become more acidic and lose oxygen. And super added to these changes are other human impacts of global significance, including overfishing and pollution. There is growing awareness that climate change is influencing ocean conditions in many ways, and that these have flow-on impacts for the law of the sea. As Ambassador Tommy Coe observed in 2019, a range of law of the sea implications arise from climate-changed oceans, including dealing with the consequences of eroding territory by addressing baseline issues and resolving the status of offshore features. However, Ambassador Coe also highlighted the reality that climate impacts are damaging to ocean ecosystems and the communities that rely on them, which prompts the question for us whether the law of the sea is destined to be a passive receiver of change or has an active role to play in addressing the causes of climate change. Now, given the date of its conclusion, Unclos, unsurprisingly, makes no mention of climate change in terms, but this does not mean that it has no relevance to the problem. Indeed, as we've heard, there have been a number of new challenges since 1982 to which Unclos has had to respond. And in many circumstances, this has been possible due to the inherent characteristic of the Convention as a quasi-constitutional text, providing a framework that can be elaborated through subsequent agreements and practice. We have seen this occur in multiple areas, including in relation to the control of marine pollution through agreements adopted under the auspices of the IMO, and likewise a panoply of global and regional fisheries agreements, including the 1995 Fish Stocks Agreement. One of the hallmark features of Unclos is its extensive provisions relating to the protection and preservation of the marine environment, many but not all of which are contained in Part 12 of the Convention. A number of these have direct relevance to addressing climate change, but they have been remarkably underutilised in practice. Article 192 establishes the foundational obligation of marine environmental protection on which other convention obligations are built. These include more specific obligations under Article 194 to prevent, reduce and control pollution of the marine environment from any source. Furthermore, Article 207 requires parties to prevent, reduce and control pollution of the marine environment from land-based sources. And in Article 212, directs parties to adopt laws and regulations to control pollution of the marine environment from the atmosphere. Now, there has been some discussion as to the scope of these obligations, particularly Article 212, and whether they could extend to embrace duties to reduce greenhouse gas emissions. In my view, they do, but the main challenge has been less one of interpretation and more one of activating these duties in governance frameworks and giving them operational meaning. There are, I think, several ways in which this could occur. One is by arguing that relevant provisions of Unclos pick up the standards set in the UNFCCC and the Paris Agreement. In other words, that the duties found in Unclos to protect the marine environment from greenhouse gas emissions are informed by obligations under those two climate treaties. This is not so much an argument that the climate treaties constitute the lex specialis, but rather that they supply the practical content of Unclos obligations, providing globally accepted international rules and standards. Unfortunately, as I will explore further in a moment, the UNFCCC and the Paris Agreement have very little to say about the ocean. And most problematically, the emission reduction obligations they established are calibrated by reference to global average temperature increases and not by reference to changes to ocean temperature, circulation, and chemistry. It is therefore difficult, in my view, to see how parties to Unclos can meet their overriding obligation under Article 192 to protect and preserve the marine environment simply by satisfying the relatively modest requirements of the Paris Agreement. While it is by no means straightforward to identify the emissions reductions required to safeguard the oceans in compliance with Article 192, this does not mean that it is impossible or should not be attempted. Unclos sits within a large, complex, complicated ocean governance framework, many components of which have an actual or potential role to play in addressing climate change. In relation to Unclos, the meeting of the states parties, SPLOS, could conceivably take an interest in the topic rather than confining itself, as it has, mostly to administrative matters. A new implementing agreement on climate change and the oceans is not beyond contemplation, although the experience with the ongoing negotiations on the conservation and sustainable use of biodiversity beyond national jurisdiction suggests that this would face major challenges. But climate issues also appear certain now to be raised in Unclos in contentious and/or advisory opinions. In respect of the latter, the creation in 2021 of a new commission of small island states on climate change and international law is significant, as it is expressly empowered to request an advisory opinion from Unclos on the topic. Now, beyond Unclos, there are other mitigation opportunities being pursued in the IMO in relation to emissions from shipping, and in relation to adaptation. An even broader collection of organisations and agencies have a function, including regional fisheries management and conservation organisations, such as the Convention on the Conservation of Antarctic Marine Living Resources. Summarising the Unclos and broader ocean governance responses to climate change to date, we can see two main elements. First, in relation to mitigation, that is, reducing emissions or storing them in the marine environment, the response has been relatively narrow, confined to amendments to MARPOL in relation to shipping emissions and amendments to the London Protocol to enable the storage of CO2 in sub-seabed geological formations. Second, in relation to adaptation, that is, seeking to lessen the consequences of climate change, we see a somewhat more extensive set of arrangements. These include efforts to reinforce baselines through physical works and by legal interpretation and subsequent practice, such as through the very important work of the ILC study group on sea level rise. And under the adaptation heading, we can also situate complementary work under regional agreements, such as the UNEP Regional Seas Programme, to reduce pollution pressures on marine areas that have the effect of compounding climate-related impacts. And we are also starting to see concerted efforts to assist marine ecosystems adapt to changing ocean conditions through the establishment of marine protected areas, both on a national and regional basis. As important as all of these efforts are, they are not in themselves sufficient to meet the objectives of Unclos in relation to marine environmental protection. To put it starkly, while Unclos has been the basis of very effective efforts to control various pollutants, such as vessel source pollution, the far more serious problem of CO2 pollution of the oceans has been left barely discussed within ocean governance circles. Instead, it has been left to the climate regime. When we speak of the climate regime, we refer to the body of rules and principles that have been adopted since the UNFCCC with the objective of preventing dangerous anthropocentric interference with the climate system. Despite the physical ocean climate nexus, the UNFCCC and the Kyoto Protocol make little reference to ocean issues. In the UNFCCC, oceans and marine ecosystems are mentioned only once. In the Kyoto Protocol, the sole reference is a negative one, deferring to the IMO the task of reducing emissions from shipping. Now, ocean impacts from climate change and ocean acidification did attract somewhat more attention during negotiations for the Paris Agreement, but there is still little in that text on these issues. The preamble to Paris refers to the importance of ensuring the integrity of all ecosystems, including oceans. However, the operative provisions are silent on the oceans. Nonetheless, despite that silence, the agreement does establish a mechanism that could be used to advance ocean-inclusive policy responses, including the nationally determined contribution, the NDC, pledge and review system, and the global stocktake. The NDC process is a central element of the Paris Agreement, requiring parties to prepare successive emission reduction commitments every 5 years. Each new NDC is to represent a progression beyond the previous NDC and reflect a party's highest possible ambition. Furthermore, NDCs are to be guided by the climate change goals set out in Article 2 of the Paris Agreement. The content of NDCs are also to be informed by the global stocktake on collective progress to occur next year and every 5 years thereafter. That mechanism makes possible the inclusion of ocean concerns, both through individual party responses and also collective decision-making under the Paris Agreement. Admittedly, to date, relatively few NDCs address ocean issues, and the failure to consider oceans in NDCs results in missed mitigation opportunities, inadequate climate adaptation plans, unsatisfactory linkages with other UN regimes and processes, including the negotiations on biodiversity beyond national jurisdiction. However, despite that sober analysis or salutary analysis, there's no reason why this should remain the case in future iterations. In addition to strengthening ocean content within individual party NDCs and the global stocktake under the Paris Agreement, there are also several opportunities for closer cooperation between Unclos and the climate regime. And since 2018, we've seen a number of important developments. These include the inclusion of the UNFCCC as a member of UN Oceans, an interagency collaboration mechanism. And more substantively and importantly, in my view, in 2020, the UNFCCC subsidiary body for scientific and technological advice held its first ocean dialogue pursuant to a mandate from COP25, and that dialogue explored ways in which the consideration of ocean issues could be elevated and strengthened under the UNFCCC and the Paris Agreement. And these suggestions included not only encouraging parties to incorporate ocean-based mitigation and adaptation action in more ambitious NDCs, but also the use of ocean indicators, ocean health indicators, such as heat, acidification, sea level, sea ice extent, and so on, to inform the assessment of collective progress in the global stocktake. And most recently in COP26 in Glasgow, it was agreed in the Climate Change Pact, in the Glasgow Climate Pact, that from this year, the dialogue would become an annual event to strengthen ocean-based action. Now, it remains to be seen whether this will lead to greater formal links between the ocean and climate regimes. Institutionally, one obvious challenge that we need to grapple with is that whereas the UNFCCC is the focal point for global climate policy and is supported by a permanent secretariat, there is no comparable institution for the law of the sea to support collaboration between the two regimes. So in conclusion, Unclos is 40 years old, or close to 40 years old. The UNFCCC is 30 years old. Both treaties have been in place now for multiple decades, and both have faced their challenges in dealing with the global challenge of climate change. Unclos has found it immensely difficult to address climate issues. The UNFCCC has found it challenging to address ocean issues, which means that the climate-ocean nexus has been a major blind spot for both. This will obviously need to change, and there are opportunities for this to occur not only within Unclos and the UNFCCC individually, but also through a strengthened relationship between the two. And in conclusion, I'd like to highlight several opportunities for this. which arise in part from the work of the UNFCCC and Law of the Sea dialogue, which began in 2021. These include, first, from the perspective of the Law of the Sea, a renewed and specific focus on Unclos obligations and how they might be implemented in relation to the control of greenhouse gas emissions. Now, there are many sites within global ocean governance regimes in which this could occur, including the emerging internationally legally binding instrument on BBNJ. It certainly could occur within ITLOS, and I think it almost certainly will. It could conceivably occur within SPLOS decisions. Self-evidently, it could occur in the work of the UN Secretary General and the UN Ocean Envoy. Now, in terms of what then the UNFCCC could do, I think it is important, and we're beginning to see this occur, that there is an elevation and a strengthening of the consideration of ocean issues in UNFCCC and Paris Agreement processes. And the Ocean and Climate Dialogue is a valuable vehicle for doing that. Third, we need to support action at a national level, including through more ambitious NDCs that include ocean-based mitigation and adaptation action that reference both Unclos and UNFCCC and Paris Agreement obligations in doing so. And finally, I think we need to take a temperature check of the oceans, a health check of the oceans in the global stocktake under the Paris Agreement to make sure that the oceans are not left out of that vital regime that is managing the global carbon system. Thank you.
Professor Stevens, thank you so much. Tour de force, a wonderfully rich contribution and presentation. I think distinguished participants, we see a number of themes emerging across the three papers this morning. One of those is the issue of convergence, whether it's the convergence of environmental principles in Unclos as addressed by Professor Kojima in her paper, or indeed the dovetailing of IMO treaty regime within Unclos. And of course, that was done very cleverly by the drafting techniques applied under Unclos. And thirdly, of course, this great challenge now that has been presented by Professor Stevens to achieve greater harmonization between Unclos and the climate change treaties. Dare I say it, it is thanks to Professor Nilofer Oral that we do have that one reference in the Paris Treaty to oceans. And I think both the oceans community and indeed the climate change community right across the world would like to thank you, Nilofer, for that intervention when you were a member of the Turkish delegation. Secondly, I think it's quite provocative when you highlight, Professor Stevens, the potential for an implementation agreement. I think there's nobody better to speak to the potential of that process than Ambassador Rina Lee yesterday. I'm also struck by the way your presentation highlighted the potential for jurisprudence, both in the context of contentious jurisprudence or indeed advisory jurisprudence from international courts or indeed the tribunal itself. One of the most striking slides that you presented was the one of the three strands of action. Firstly, on mitigation and indeed the initiatives that have been taken to decarbonize shipping. And of course, that goes very much to the mission of the IMO. And you instance MARPOL and the London Protocol amendments, and they have been very important. In relation to adaptation, you highlighted the importance of baselines, and of course, there's ongoing work by both the International Law Commission and indeed the International Law Association. And my understanding is my dear colleague, Professor Clive Simmons, will speak to that later today. Crucially, you've highlighted the importance and the role that UNEP's Regional Seas Programme can play, and of course the crucial role that the BBNJ agreement can play in due course in relation to area-based management tools in marine protected areas. And I think that goes directly to your summary side, where we need to have action on a number of fronts, both in the context of implementing Unclos, as well as in the context of implementing the climate change treaties, and quite crucially, perhaps most importantly of all, the NDCs. I think there's one or two striking aspects to this. First and foremost, the importance of science, and we see very important initiatives, and I would highlight the Global Ocean Assessment, and indeed we've contributed to that here in the Institute. Likewise, the IPPC Special Report on Oceans and the Cryosphere in 2019 has highlighted the fundamental importance of oceans, both to mediate climate, as well as the effects of climate emergency on the oceans. And that goes very much to the extensionist identity and future of those communities living in small island developing states right across the world, all of whom, dare I say, are parties to the Law of the Sea Convention. I think this discussion has been very fruitful, and of course, it opens the doors to the questions and answer session. And I'm very happy to say we have over 20 minutes now. So if you could direct your questions from the floor, first and foremost to the panelists, and if you can keep your interventions brief, we would appreciate that. So I'll turn over the microphone to the conference organizers this morning in Singapore.
Thank you, Professor. We have about 20 minutes for questions. We have one question from Professor Stuart Kay.
Thank you very much. They were all exceptional presentations. I have a question that's perhaps best directed at Tim, but happy for the other presenters to address it if they wish. One of the great efforts of the 40-year period that we had was an effort to try to produce an instrument to deal with land-based sources of marine pollution. And it's one thing that didn't eventuate, and I'm wondering whether it's something that should ultimately be revisited, or perhaps making use of the approach adopted to put some teeth into Article 192 in the South China Sea arbitration is the better way to resolve trying to strengthen approaches to land-based sources of marine pollution. So happy for your thoughts.
I'm happy to jump in first there. Professor Kay, thank you kindly for your question. Yes, discussions have been around now for a long time in terms of dealing with land-based pollution, and as all of us who teach Law of the Sea know, when we go through with students the main sources of pollution, they are constantly surprised that around 80% or more comes from land-based sources, including from the atmosphere. When we think of pollution from, say, a coal-fired power plant as being a land-based source of pollution, because it releases pollution into the atmosphere that ultimately finds its way into the oceans. I agree, it would be time to revisit some kind of global agreement. And I think you're seeing, particularly in relation to marine plastics, some appetite on the part of states for action in relation to land-based sources of pollution. So maybe we kind of need to strike while the iron is hot and see if we can push the debate further and expand it to include not only damaging marine plastics, but other sources of land-based pollution. And again, not only on a regional basis, where there has been some success, particularly if you look at regional seas agreements, but globally.
Thank you very much, Tim. Do we have any other questions from the floor?
We have one from Director Nilofer Oral.
Hi, I'm Amanda Chong from the Attorney General's Chambers, Singapore. I have a question for Professor Kojima. So one of the key issues under the environmental impact assessment part of the BBNJ negotiations is the applicable threshold for EIAs in areas beyond national jurisdiction. And there is a divide between delegations who prefer the threshold under Article 206 of Unclos, that is, may cause substantial pollution of or significant and harmful changes to the marine environment, and delegations who prefer the threshold under the Antarctic Treaty, which is more than minor or transitory effect, which most of us have understood to be lower than the Article 206 threshold. So what is interesting is that at IGC4, several delegations made the argument that this more than minor or transitory effect threshold is in fact consistent with the Article 206 threshold and may in practice amount to the same thing. So I wonder what you make of this argument, especially, since you spoke about the potential of Unclos to be a site of progressive development of general environmental law principles. Thank you.
Hi, thank you for your question. I understand that there's a disagreement among the delegations with regard to the threshold of the standard, and I think the threshold argument is evolving at the moment. And what we have seen as a result of the process of 40 years is that we have the obligation to conduct an EIA as a customary international law, and this is a firm direct obligation and Unclos, and also in the general principle in environmental law. So I don't really have an answer to your question, but the reference to Antarctic Treaty is one good development that we should maybe create a common, we should continue the discussion and create a common understanding about the content of this threshold, which could be agreeable at the international level. So I'm sorry, I cannot really answer, but this is what I could say. Thank you.
Yeah, look, this is a hot ticket issue at the BBNJ negotiations. It's one of these, shall we say, issues that will have to be resolved if IGC5, if the negotiations are to be brought to a successful conclusion. And I suppose it leads to a broader issue. And I would put this question to maybe all of the panelists, which is the danger of subsequent instruments to Unclos of diluting obligations or lowering the thresholds of the standards that apply under Unclos. Do you think this is a real risk? And okay, it's just a general question, perhaps, for the panelists.
Perhaps as they reflect on it, Professor, I would just give the mic to Dr. Nilofer Oral to also propound her question.
Thank you, Pia. Thank you. First of all, dear Ronan, thank you so much for joining us at an absolutely god-awful hour, but you are simply brilliant. You're so alert, and we really appreciate that. We're sorry you could not join us, but thank you so much. This has been an outstanding panel. Each of the presentations really exceptional, as Professor Kay said. So I will very quickly, just two questions, one to Professor Kojima, brilliant presentation. And on the issue of environmental principles, I think you really brought out the role of ITLOS and the arbitration tribunals in this systematic integration. You may also be aware, of course, that there was the Global Pact for the Environment that sought to bring under one framework environmental principles. Do you think we can rely on the role of courts for this, or would such a standalone, separate treaty, which could be incorporated into Unclos in terms of updating it? What do you have any thoughts on that? And then to Professor Tim Stevens, who really, you're one of the first to write about oceans climate and particularly ocean acidification. And so you are truly an expert that I've looked to for guidance on this. And you've given a very clear presentation of the enormous gap, the chasm and the problems, and the possible ways to approach it. But when you speak about the national level, my question has to do with, yes, encouraging NDCs, but we also know that there's a lot of climate litigation going on now at the domestic level. And we had a presentation recently, 1,500 around the world based on the Paris Agreement. Is there a role for Unclos to be used as a domestic vehicle to really push states? Because I think you made it so clear, how are we going to push states? It's not happening under the climate regime, and yet Unclos has this fantastic, these provisions that are so clear. So I'll stop right there. Thank you.
Hi, thank you for your question. I guess I will answer first. Creating a global pact, one global pact, combining the two regimes. My opinion is that, of course, maybe it's ideal, but it might take a lot of time to draft such an agreement. And I think the convention has the possibility to integrate, as Tim already highlighted with many provisions. The Unclos has the possibility to evolve and integrate the climate challenge. So I think it's maybe we should take a step that maybe the International Tribunal could maybe give an advisory opinion about as to whether greenhouse gases can be considered to be a source of pollution, and the scope of the due diligence obligation under Part 12. This will be maybe easier path to integrate the regime, in my opinion. Thank you.
Tim, please.
Professor Oral, thank you for your comments and for that great question about the chasm that we faced and whether we can bridge that chasm through climate-related litigation, including litigation which draws on or refers to Unclos obligation within domestic courts and tribunals. And the answer to that is, well, why not? There's no reason why, in principle, Unclos shouldn't be referred to in domestic climate litigation in the same breath as, say, the Paris Agreement or the UN FCCC. But the fundamental challenge, as we know, is that not all states fully implement into domestic law their international law obligations, which makes it hard to run a case, to have an actionable case or dispute. So certainly in the Australian context, we don't have any generalised implementation of Unclos as a matter of Australian law. So there's no kind of rights or duties or obligations that form part of domestic law that can easily be litigated. And they might come up tangentially, say in proceedings relating to environmental approvals, but they don't provide in and of themselves a cause of action. But that is an area of potential law reform. and maybe it's something worth looking at. And another reason why we should advance the domestic implementation of Unclos further.
Yeah, maybe before I turn the floor over to Dr. Lasaminsky, I'd like to take the chair's prerogative and comment on this. And I think it's crucially important. And for instance, the European Court of Justice has been very clear in Commission versus Ireland. This was the case that followed on from the Max Planck application for provisional measures in Unclos. In the European Court of Justice judgment, the court said that all European Union law in relation to the ocean had to be read in light and interpreted in the context of the provisions of Unclos. So they see Unclos within the hierarchy of European Union law as below the European treaties. That's the foundation treaties for the European Union, but certainly higher in the hierarchy than secondary legislation and other instruments. And that's quite crucially important in the context of the application and interpretation of climate change obligations through the prism of Unclos. And I suppose it goes to say that yesterday Judge Hoffman highlighted the importance of contentious advisory jurisprudence of Unclos in relation to climate change obligations. Now, without further ado, and I suppose this is a contemporary issue as well, we have a great question for Dr. Dorota, which relates to your reference to MASS, which is focused on shipping. And the question says, are there any discussions at IMO in relation to underwater autonomous vessels, or if this falls outside of the scope of the IMO initiatives? Subsurface, underwater.
As you might be aware, the IMO treaty regime applies to commercial ships operating internationally on international voyages. So the IMO regime does not apply to any warship or naval ship or any other military ships or equipment. I'm not aware of any underwater ships that would be used for commercial purposes, for the purposes of carrying cargo globally. And if we are talking about underwater vehicles, these vehicles are mainly used for the military purposes. As such, IMO regime does not apply to such vehicles.
Yeah, thank you very much. And of course, this is hugely relevant for marine scientific research and indeed, dare I say it, for the BBNJ negotiations, because much of the research that will be conducted in the future in the deep ocean will not be conducted from surface vessels. And I suppose it's fully understandable how Unclos provisions were drafted in the context of surface vessels. And perhaps maybe the other two panelists would like to comment on this. Thank you very much.
Professor Kojima, you can go first if you wish.
Yes, the connection was a bit lost. Could you maybe repeat your question?
Yeah, it's would you like to comment?
Comment.
Yeah.
Well, I don't have any comment at the moment. You mean to other panelists?
No, it's okay. It related directly to this question.
Okay. Okay. No, I have no question. I have no comments. Thank you.
Okay. Professor Stevens.
Look, I've got nothing to add to that particular issue, Ronan.
Yeah, look, it's a very topical issue. We're doing a big research project here in the university, and we'll be hosting a big webinar about automation and particularly the use of robotics for surveying and inspection of ships. And this, again, of course, is one of the big challenges. It's the convergence of technologies. Perhaps one point I might put to Professor Stevens is the technology transfer provisions have worked much better under the technology mechanism under the climate change regime. And do you think the law of the sea community, and particularly the BBNJ negotiators, should mirror those arrangements in the context of the new instrument?
Look, that's a really interesting question. I'm not sure I would fully agree that the technology transfer system within the climate regime context has been a tremendous success. There are plenty of weaknesses, but I think it's fair to say that there are a number of examples of concerted effort to share knowledge, particularly around certain clean energy technologies among parties to the UNFCCC and the Paris Agreement. And that kind of technology transfer we haven't really seen to any real extent in the law of the sea context, including even within the context of deep seabed mining, where we do already have a very highly developed regime. And perhaps that's the most important example to look at, to see if we can copy some of the experience from that. And hopefully it'll be a good experience across to the BBNJ context, because I think there's lots of analogies there between the deep seabed mining regime and biodiversity beyond national jurisdiction. Both of those regimes, of course, are animated by a fundamental interest in sharing the benefits of the exploitation of what is ultimately common heritage or common concern.
Thank you very much for such a comprehensive answer. And I think we can go back to the participants. My understanding is Judge Cormack would like to take the floor. Please.
Thank you, Professor Long. I would like to commend the distinguished panelists for their contribution this morning. I have been informed and educated, and as I say, I would like to commend you for the considerable intellectual investment you have made in developing the environmental provisions of the law of Unclos. I think you deserve our commendation, as I said. But you know what I'm concerned about? I think the discussion has moved on, as you all know. At the time of the negotiation of Unclos, the argument was whether having a reference to environmental law was not fragmentary. But I think now you have established beyond any doubt, I wouldn't say even reasonable doubt, that that argument is no longer sustainable. If I were drawing up this program with all due respect to the planners of this conference, in the light of the evidence, I wouldn't even talk about Unclos and other regimes' harmony or fragmentation. I'll just say harmony and development. That's what you've done. You fleshed out those provisions of the Law of the Sea Convention, and that's why I say I would like to commend you for the efforts, the investment you've made. So, of course, I personally, if I may speak, I never got involved in that argument about fragmentation because I thought it was artificial. It was artificial just as in the other sphere when George Tulio Trevis again spoke about fragmentation of international law with the establishment of Unclos. I never got engaged because, again, I thought it was artificial. And as time has proved us, there has been no fragmentation. The fact of the matter, of course, we as lawyers, we like to debate. And once the issue was raised in the case of the court by two that I know of, two distinguished lawyers, that the establishment of Unclos might lead to the fragmentation, but as I say, it was artificial. And likewise, in the case of the environmental provisions of Unclos, I don't see the regimes that are now in place as a fragmentation, but as a development. So perhaps we should go beyond the argument whether it is fragmentation. Now, we should not continue to flog a dead horse, as they say. Thank you very much.
Thank you. Thank you so much for that wonderful intervention. And I think if our panelists would like to commentate, I think you speak with such a voice of reason and wisdom, a distinguished judge, that we have to reflect very carefully on this in terms of how we articulate the development of the Law of the Sea Convention, of course, other international treaty regimes. I'm very conscious of the time, so perhaps I would just turn to the panelists and ask them if they have a final comment, and then, of course, we would turn the session over to the organizers. So, Professor Kojima's final comments?
I just would like to thank Judge Koroma for his comments. And indeed, I agree that it is not harmony and fragmentation, but harmony and development. And in terms of development, I also want to comment on Tim's remark a while ago, because technology is developing, and in that regard, under Unclos 12, there's Article 196 that states shall take all measures necessary to prevent, reduce, and control pollution of the marine environment resulting from the use of technologies. And these technologies can be very much varied from, from nanotechnology to, use of mass even. So I think we also should pay attention to the development of discussions on Article 196 in the future. Thank you very much.
Thank you, Professor Kojima. I'd like to ask Dr. Dorota Las-Seminska for your final comments, please.
Yes, thank you very much, Professor Long, and thank you, Judge Koroma. I could not agree more with you. As I said at the end of my presentation, for us, it's a harmony, it's a harmonious system. And in the context of climate change, because this panel turned to be a lot about climate change as well. As was mentioned, the Paris Agreement turns everything what is related to shipping to IMO. And whether it is MARPOL and all its 6 annexes, or London Convention and London Protocol, Ballast Water Management Convention addressing the transfer of invasive species between the various parts of oceans, or anti-fouling substances covering the ships. Each and every piece that we are addressing at IMO forms a regime that aims at preventing of all kinds of pollution, whether atmospheric or emanating from technologies. It forms part of the very, very robust regime, and we are addressing it piece by piece, and all those pieces, all those puzzles compose one harmonious regime that I think is very well composed within the Unclos and within the overall goal of preventing or minimizing the contribution of shipping into the climate change. Thank you.
Rosa, thank you very much. And perhaps the final words now to Professor Timothy Stevens, please.
Thank you. Well, I would simply say there's nothing much better in international law work than receiving a compliment, as this panel has done from Judge Koroma. Thank you very much for your observation. And I would simply say I wholeheartedly agree. And I think if your attitude was to be taken on more broadly, we would have fewer issues to deal with.
Okay, it behoves me as chair of the panel to thank the speakers. It has been a wonderfully rich discussion. I'd also like to thank the audience in person in Singapore, and of course this wonderful community right across the world And of course, we will try and answer some of these questions that you've been posting online in due course, because there's going to be a record of the conference. So good morning, good afternoon in Tokyo and in Sydney. And of course, we wish you a very successful conference for the rest of today. Thank you.